A very good evening to all my dear students. I know how eagerly you have been waiting for today's session. The feeling is totally mutual at this side also. A very good evening, dear Vishal, Soumya, Asta. Okay, Asta, if you have any doubts, feel free to ask. Miss Divya is saying that I did not know about these classes. Now I've started studying. So don't worry, Miss Divya. Even if you have started attending the classes now, all the recorded lectures are there on the YouTube for September 2025. So you can refer through over there but be 100% attentive from today onwards. All right. Good evening, Almaz, Pratika, Shailaja, Rajmeet. I cannot see any of the students on the portal yet, but yes, there are many students on the chat box. So good evening, Miss P, Miss Varsha, Kirti. All right, Mr. Vishal, I'll just get it checked from the admin if the chapter 3 prospectus notes have been uploaded or not. Thanks for reminding us, Mr. Vishal. I'll just get it checked, okay? So don't worry. Miss Pragya, Anurag Mishra, Julie Kumari. Okay, Rajveer, I have noted that point. We'll get it checked at the back end. Don't worry about that. All the notes and PPTs, whatever we are doing in the class, will be given to you, along with certain assignment questions also. All right. So a very good evening to all of you. And I hope you have revised what we have done in the previous class related to share capital and debentures. And all right, Mrs. Priya Sharma, we look into the matter. Don't worry. Right now, we are doing the chapter 3, so we cannot go to chapter 2, okay? All right. So we have already completed almost half of the chapter, but major chunk of the chapter is still left to be covered. And today, we'll be covering some of the very interesting as well as important topics. Somehow, like alteration of share capital will be coming up today. How you can change your share capital. Alteration means either there is an increase or decrease in the share capital. At the same time, there will be a comparison with Section 66, which specifically talks about the reduction of share capital. How the share capital can be increased, decreased, referring Section 61, and how the reduction of share capital happens. Now, we have previously done section 54, but this is the later part of the chapter, which comes after section 60 to 69 till it goes. And then from 71, we have specific section related to debentures. But the earlier part of the chapter is totally related to your equity shares, preference shares. We have in detail discussed how the preference shares are issued, how the redemption of preference shares happen, which I'm going to take a test also of all of you because we recently completed section 55 in a previous lecture. Before that, we have done section 54, which was very, very important section. That is sweat equity shares. All right. We did certain MCQs also at the end on that. So today we will be doing ESOPs. So we told you earlier also, sweat equity shares are also given to the employees or directors for the hard work and value addition that they are bringing to the company. But today we will be doing at length discussion about section 62, wherein we try to understand how the further issue of share capital is happening, how the rights issues are given to the members, how the ESOPs are issued. ESOPs is employee stock option schemes. So employees are given an option that we are giving you a recognition in our organization that we are issuing shares to you. Certain granting and vesting period we will understand in that specific section, and employees have the option to convert that into their equity shares. So that is another method of raising the share capital. So you can very well relate how the entire Companies Act is so very interrelated. We have discussed in detail about the prospectus in chapter number 3. Sorry, we are doing chapter 4. Okay, we are in chapter number 3. We have already done. So many of you have written a notes of chapter 3. I also got confused. So notes of chapter 3 prospectus, you will definitely get, even if it's not there. I'll get it checked at the admin why it is not appearing. It should have been appearing, but not to worry, you will still get it. Okay. Apart from that, we are doing chapter number 4, which specifically the summary that I gave you, that is for chapter 4, that is share capital and debentures that we are doing currently. So we have had a detailed discussion about how the variation of the shares happens, how the equity shares with DVRs are issued. I hope no doubts in DVRs. So quickly tell me, when DVRs are issued, do we need to pass an OR or SR? Let's have a quick recap of what we have done till now so that we can move towards a fresh topic. Asta Sethi is asking, ma'am, in Rule 9, all companies are covered. What is the difference between Rule 9 and? So, Asta Sethi, I told you Rule 9 and 9 is only the reference which has been given for the unlisted companies to follow the procedure for demat securities. We don't have to learn the entire process, but whatever I have shared with you in the class, that much information is sufficient. In fraud definition, what is the person? Any other person? Okay, Asta Sethi, we'll take it up when we open the study material. OR is the correct answer. Example 4 at page number so and so, copy file. Okay, Priyanka Pandey, remind me about this example number 4 when I open the study material. So far, Memory, Anubhav, Varsha, Soumya Almas, Miss P, Praveena, Prem Kumar, Shailaja. Oh my God, not a single child has given a wrong answer. Priyanka Pandey, Asta Pragya, everyone has given the correct answer. Yes, ma'am, OR needs to be passed for DVRs to be issued to the employees, to the members when the differential voting rights are issued. Now we will be talking about the share certificate, section 46. I hope you all remember the signing part also. 2 directors, at least 1 or 2 directors shall be a person other than managing or whole-time director also. You have to prove them. If you have lost your share cap certificate, then proof has to be given. And this was the time period. Can anyone tell me what is the renewal and duplicate share certificate forms? In what form is the renewal and renewed and duplicate share certificate issued by the company? The hint for share capital is SH forms are used, so don't go into PS forms. Almas, Asta Sethi, and Soumya Ananya are the first one to give the correct answer. SH2, Rajveer Ray, very good. So here it is written, the renewed and certificates, duplicate certificates are to be maintained in form SH2, which you have to file with the ROC also. It has to be kept at the registered office of the company where the company has set up the register of members is kept. All right, and this point is also important. Company secretary or any other person authorized will keep the custody of these share certificates. After that, we had detailed discussion about section, after section 43, we did 46. Then rules of 5 and 7, share certificate, original share certificate children in SH1, they are issued. I remember showing you these SH forms also. Very good, children. That means you have been studying very well, and time period for preservation was 30 years. And if it is a disputed case, then it will be preserved for permanently. Then it will be preserved permanently. Very good. Forever. Good. Then 47 was quite simple. Equity shares have a right to vote on all the resolutions, but preference shares generally vote if the dividend has not been paid for 2 or more years, then they will be voting on all the resolutions. Otherwise, they only have a say in respect of the dividend, in respect of winding up, and when their repayment of capital is considered. Variation in shareholders' rights was very, very important section. That was section 48. We have discussed in detail the consent in writing of not less than 3/4 of the shareholders is taken or SR is passed. Whatever is convenient, either of the thing can be. But my dear students, if one shareholder's rights are being varied and it is affecting the other class shareholders, if you are changing the rights of the equity shareholders, and in case you're changing in such a way that the shareholders who are holding DVR rights, they are getting affected, then do we need to pass the SR for these DVR shareholders, that is another category of shareholders, or their 3/4 consent is required, or both is required? What will be your answer? Do you need to take their consent or you need to pass the SR for them? Excellent, ma'am. Only 3/4 of the consent is required. No SR is required. Oh my God. Brilliant students. Very good. Mr. Prem Kumar, excellent. And dissenting shareholders, as I know, it's your favorite. 10% of the shareholders will go and file a case with the tribunal within 21 days was the major point to remember over here. And whatever decision of tribunal, it will be binding on the company. After that, children, I think section 49, 50, 51, you can revise it in a more wider way than me revising with you, because you have been doing about these things since childhood. Shares should be issued on uniform basis. जितना पैसा सबसे मंगवाया है उतना ही partiality नहीं होनी चाहिए. You have to be equivalent, uniform basis. All the shareholders have to be treated. Again, 50 was related to your calls in advance. No voting right is given. But do we pay anything else to the people who are paid calls in advance? Ma'am, they will not get any additional dividend. They will not get any additional voting right. But do we give anything else to them? Yes, Rajveer, Almas, Miss P, Miss Soumya, so much attentiveness in the class. I'm loving it. Very good. Priyanka Pandey, excellent, ma'am. They will get interest. And what was section 51 talks about? Now your turn. Ananya, good. Everyone. Vemery, Shailaja, excellent. Let me see the students on the portal also. What does section 51 talks about, children? Please tell me. Payment of dividend, excellent. With respect to the shares that you have paid up, you will get the votings and dividend right with respect to that much of the share capital. Mr. Kevin, I'm getting your answers now. Excellent. Mr. Kevin Norhana. Nice, nice, nice. Asta Sethi, what is your doubt in respect of that? That is for the preference share capital. Okay, Miss Asta Sethi, that is where the voting rights of the preference shares, they will vote if there is a matter related to the repayment of share capital. You remember the preference shares holders are given the preference for two things, for the payment of dividend and where the share capital is to be returned. But there, if your share capital, you are bothered because your share capital is not being returned, then you will get the voting rights. Okay. Payment of dividend, very good. Pragya, 51 section, all of you have answered it beautifully. Now, issue of shares at a premium, section 52, which I have a very, very important question. Everyone knows now what is security premium amount. Whatever premium that is a higher amount if the shares are issued, the amount will go to the security premium accounts. What is the usage of the security premium amount? Quickly tell me the 5 usage of shares when they're issued at a premium. What are the 5 uses of securities premium account? Very good. Excellent. Vishal, Rajveer, Ananya, all those who have written quickly, Julie Kumari, Priyanka Pandey. I know it's too much to write so fast. So, well, I can judge it out that you have revised it. For issuing the unissued shares, writing of preliminary expenses, issue expenses, and for bonus shares, payment of premium on redemption, and buyback of securities. These are the purposes for which the security premium amount can be utilized. After that, can we issue the shares at discount? This was the exception, you remember, section 133. Then only the 3 things, redemption and preference shares, is not allowed in these 2 cases. Other than that, 3 purposes can still be used. Can we issue the shares at discount? No, ma'am. Issuing of the shares at discount is void. Only sweat equity shares is the exception. Miss Vidhi, you can type your queries because we have just started with the class, so you'll not be allowed to unmute in between. So, Miss Vidhi, you can type your queries if you want to ask it. Okay. All right. Yes, sweat equity shares, and if it is a debt restructuring for the creditors. Excellent, Ms. Asta Sethi. For the creditors also, when you're restructuring of the debts, when you're converting your debts into shares, then also the shares can be issued at discount. All right. For sweat equity shares, we all remember SR was required and all the detailed discussion we have done. I'm not going to go into much of the detail over here. Then section 55. Section 55, what did we learn about section 55? It was for the issue of preference shares, redemption of preference shares. Preference shares needs to be redeemed within a maximum period of how much? 20 years or 30 years? Was there some confusion? Preference shares can be held maximum for 20 years. Okay, everyone says 20 years. Then what was the 30-year exception? What was the exception for the 30 years? For the infrastructure projects. Remember, for infrastructure projects, the company may issue the shares for a period exceeding 20 years, but it shall not be more than 30 years, provided 10% of such preference shares shall be redeemed starting from the 21st year. Very good. Everyone is clear on this as well? Great. So capital redemption reserve we were creating equivalent to the nominal amount of shares. Can this, what is the purpose of this CRR? It can be used for what purpose? Can anyone tell me? CRR can only be used for What was the purpose of the CRR? Excellent. Oh my God, they all remember, ma'am, for issue of fully paid bonus shares. Very nice, children. And CRR is reduced in the same manner as paid up share capital is reduced. I told you at that time that this line might be difficult for you to digest right now. But today, when we do in detail discussion about section 66, there you will understand about this point. Mr. Kevin, I'm getting all your answers and absolutely correct answers given by Mr. Kevin also. Good. Anubhav also, Shailaja, Julie Kumari, Mr. Sunil Kumar, excellent. So now let's move on to section 56, that is transfer and transmission of shares. Can we transfer our shares to someone else? Ma'am, when we did the difference between public company and private company, you told us private company shares are freely transferable, but public companies, some of the restrictions might be imposed when the public company is trying to transfer its shares. What is the meaning of transferring of the shares? You hota kya hai shares transfer? Section 56, 57, 58, 59, they all are interrelated. It's a very, very huge section, very big. It sounds very tricky and complicated at certain times. But when the word transfer and transmission becomes clear in our mind, the topic becomes very, very simple. So what is the meaning of the word transfer? क्या हम इसे सिंपल लैंग्वेज में बोल सकते हैं अपने शेयर्स किसी और को दे रहे हैं, ट्रांसफर कर रहे हैं? Are you selling off your shares to someone else? Simple. You're transferring for consideration, excellent, for some payment or for non-consideration. Whatever is the cases, we'll discuss in detail, whether they are given for some consideration. But where you're transferring your shares, now when I'm selling my house, I need to make a sale deed for selling of my movable property. Now when I'm transferring my shares, I need to make a transfer deed. An instrument will be made, that is a transfer deed, a document which will contain the entire details about who is the transferor and to whom they are transferring their shares. At the same time, what is the meaning of the word transmission of shares? In transmission, and here I'm selling my shares to someone else. I'm voluntarily giving my shares. Mr. A wants to transfer his shares to Mr. B. So he will get the transfer deed made. But in transmission of shares, Mr. Ram is the holder of shares of Reliance. He is holding 10,000 shares of Reliance. Mr. Ram is holding 10,000 shares of Reliance. Tomorrow, if Mr. Ram dies, who will get the shares? His legal heirs. Here, the shares have been transmitted to him. So in transmission, because of by operation of law, because of death, the legal representatives are getting the shares, or maybe because of insolvency or any other cases, here automatically the transmission of shares is happening. But in the first part of section 56, we'll understand how the transfer takes place. Clear? Now everyone has a clear picture in mind that what is the meaning, literal meaning of transfer and what is the about transmission. Now let's try to understand what law is telling us. Law mein kya kehta hai ki how the transfer is going to take place and how the transmission is happening. So when A is going to transfer his shares to B, so this is our example which we'll be understanding. A is going to transfer his shares, then they will make a transfer deed. So we'll say A is the transferor and B is transferee. So transferor is giving the shares to transferee, so he will make the transfer deed. Instrument transfer must be executed by both. Executed means they will make a transfer deed. That is, a transferor and transferee will sign a document that all right, now we are going to transfer the shares from one person to another. Now this instrument means ये transfer deed जो बनता है, it is in the form SH4. It is in the form SH4, which again, SH4 and SH5 are two forms which I'll be showing you maybe after the break, somewhere in between, just remind me, okay? SH4 is the form which is used for, which has the prescribed details about how the transfer details are to be handled. And this is to be used if the shares are held in physical form. My dear students, if the share are in demat form, then you don't have to go into this entire procedure. Then you're already doing your trading on the stock market. Here it is talking about where I'm having an instrument of transfer deed is required, where the shares are held in physical form. So मैंने अपना ये share certificate किसी और को देना है. Then the physical copy is. So the name, address, and occupation of the transferee will be given. Why are you giving the details of transferee? Because transferor is already a member with the company. Company already knows about the transferor. He knows who is Mr. A. So whose detail needs to be given, children? In case of transfer, whose details needs to be given? We need to give the details of transferee because that is the new person who is going to come and join the company. Instrument of transfer should be duly stamped and dated. Why do you need to put the date? I will tell you when we move ahead to other sections, because sometimes the refusal happens. So you have to tell what is the date on which the transfer took place. So it will be duly stamped. This instrument, Mr. A, will get it stamped, deed will be made, and all the name, address, and occupation of transferee will be given. And he will file this with the company that, look, company, I am Mr. A, and now I am handing over my shares to Mr. B. And what is this form? SH4 form में transfer हो जाए. The transfer instrument must be delivered to the company along with the certificate relating to the shares within 60 days of its execution. So it should be dated. So whatever date it is made, within 60 days of its execution, the instrument shall be transferred. If the share certificate is not in existence, then the allotment of securities should be filed. So if your share certificate is lost or it has not been delivered, then you need to give certain kind of indemnity to the company. Your letter of allotment will be given and you need to indemnify that कल को कोई नुकसान होता है. If my share certificate is got lost, if it is not available, then how you will be fulfilling, how you will be compensating for that loss. But such instrument has to be delivered. Either the transferor will deliver it to the company or the transferee within 60 days along with the share certificate. And if share certificate was not issued, then what will you give? Then you will give the letter of allotment of securities. Either you have the share certificate or you have the letter of allotment of securities. Allotment of securities was in which section? Section 39. We learned the securities were allotted to you. Either the share certificate has been given to you or you're having that letter of allotment. तो यहाँ तो आप शेयर सर्टिफिकेट दे देना या फिर आप लेटर ऑफ अलॉटमेंट. But where the transfer is between the persons whose names are entered in the records of depositories, above provision will not apply. Now, Asta was asking about Rule 99A. See here also again, simple he is talking about. Records of depository means your shares are in demat form. When your shares are in demat form, then do you need to follow this procedure? Tell me yes or no. Okay, very good, Anubhav. Yes, Miss P, that point will be coming in detail again. यहाँ तक सबको clear है. Transfer deed has to be made. Transferor will make it. Will transfer the shares to transferee. Name, address, occupation of transferee will be given. Duly dated and signed. What is the form number for transferring the shares? SH4. Within how many days we have to inform the company related to this transfer details? 60 days. If the share certificate was not issued, then what will you file with the company? Letter of allotment. Excellent. If the shares are in demat form, then do you need to follow this procedure? Good. Now, listen again this point, I'll clarify. If the instrument has been lost or it has not been delivered to the company within 60 days. Now, you did the execution on 1st April 2025. So within 60 days, how many will be 60 days? 30th April and then by 30th of May, till 30th of May, within this time period, the transfer deed should have been filed with the company. If it has been lost, you have lost the transfer deed, the document that is SH4, or if it has not been delivered to the company within 60 days of the execution, then the company will do the transfer on the basis of indemnity. First of all, let's go back to our Indian Contract Act chapter of indemnity. Please tell me what is the meaning of the word indemnity. In the layman's language, मुझे simple बताओ what is the meaning of the word indemnity. To make good the loss, excellent. To compensate, to indemnify, very good. All of you understand the meaning of indemnity. So here the company is asking the members to sign the indemnity that we are recording the transfer only if you give us an indemnity bond, that tomorrow if it is a failed transfer or anything happen, you will have to indemnify the company. So company will say, please sign the indemnity, then only we will record the transfer. Aapne document banaya, that document has been lost, and now you're requesting me to transfer your shares to Mr. B. Who is Mr. B? I don't know. I don't have any document. So the company is requesting them to do the transfer on the basis of the word used, indemnity. सिंपल हिंदी शब्दों में कंपनी बोलेगी हमें लिखित में कुछ दो, कल को ये अगर ट्रांसफर वैलिड नहीं है, सो आपको कंपनी को इसका नुकसान का भुगतान करना पड़ेगा. Clear? Now it's clear. I have told you in detail in Hindi. So coming back to English, the transfer document, if it has been lost or within 60 days it has not been delivered, then the transfer will take place on the basis of indemnity, whatever the board will think fit, whatever indemnity they want the transferor to sign. Okay? When the application is made by the transferor alone, and it relates to partly paid up shares. Now, these are very, very important points. This is the first point related to indemnity. This is the second point, which is talking about the partly paid up shares. Now, what is the meaning of the word partly paid up shares? Let's write an example first. Let's understand what is it trying to tell you. A agrees to transfer his. Please keep writing down these examples with me because they're not written anywhere else. I just make you write down whatever is coming to my mind to make the concept clear to you. A is transferring the shares to B of ABC Limited Company or Reliance, whatever you want to take example. Say, for example, rupees 2 was still uncalled on these shares. A is transferring shares to B of ABC Limited. The share price per share was rupees 10. And rupees 2 was still not called. So how much Mr. A has paid? So A has paid rupees 8 per share. Am I right? How much is pending to be paid to the company? Rupees 2. So can we say the shares are not fully paid up? These are partly paid up shares. These are partly paid up shares. Now, if A goes to company and asks the company to enter B's name in the register, what is happening? Application is being made by the transferor, means here we are talking about Mr. A. He will go and tell the company that please transfer the shares, register the shares. But company will say these are partly paid up shares. How do I know that Mr. B will now pay me rupees 2? कंपनी को क्या टेंशन हो रही है कि 10 रुपए का शेयर था, आपने 8 पे करे हुए, 2 rupees is still pending. Company will have a doubt. You are transferring your shares to Mr. B. So company will give a notice to Mr. B, that is transferee, in SH5 form and tell him that please give us no objection within 2 weeks from the date of receipt of notice. Now, what is the meaning of this line? This red highlighted line means A will go to the company and tell the company that, look, I am transferring the shares to Mr. B and my shares are partly paid. Company will go and ask Mr. B, look, this Mr. A has told me, has given me SH4. He wants to transfer his shares to you, but this rupees 2 per share is still pending. Are you ready to pay rupees 2 in future to us? If you are ready, then please, you will give us the notice in form number SH5 and no objection certificate should be given. आपको कोई objection नहीं होनी चाहिए इन shares को अपनाने में, क्योंकि because company cannot be at loss. The company will give the notice and want that no objection certificate so that company will get its rupees 2 per share. Now B will have to pay the balance rupees 2 per share. Okay, so where you have written in my example, here you will write down and continue. After the transfer deed happened, Mr. B will have to pay the balance rupees 2 per share. Mr. Kevin, stamping is related to your transfer deed, whatever you're transferring, there the stamp is necessary. Common seal specifically relates to about your share certificates where you're issuing. Okay, so here you're doing a voluntary transfer. You are informing the company. Company has not asked you to transfer the shares. Is that clear? Company will, yes, Mrs. Priya Mishra, company will give the notice to transferee, that is Mr. B. Absolutely correct. So let's have a quick recap of what we have discussed. It's very simple and little lengthy, okay? So don't worry. But I'll make it help you learn here only in the class. So don't worry. पहले क्या हुआ? Transfer deed बनाई. Details of transferee were entered, name, address, occupation. SH4 was filed with the company. We filed the form. Let's go back here. Transfer deed was made. Everyone is clear. Transferor and transferee. A is the transferor. B is the transferee. Details of transferee was given. Yes, ma'am. Duly stamped and dated. In the SH4 form we have used. The shares are in physical form. Within how many days it has to be delivered to the company? Within 60 days. If share certificate is not there, letter of allotment, DMAT है तो हमें ये follow नहीं कर. सबको clear. Next page. If the instrument is lost, what will you do then? If the instrument is lost, within 60 days, if it is not given, then what will you do? What will you do? Company will ask for indemnity. Okay? Letter of, okay, that was for the previous one, letter of allotment. Anubhav, excellent. Indemnity will be required. Company will ask that give us an indemnity that tomorrow company will not have any loss. If your shares are transferred, if it is a partly paid up shares or the company is not getting the payment or it was a wrong person, you will have to indemnify the company. Clear ho gaya sabko ye wala point? Okay. Now, partly paid up shares. This was the point related to indemnity. Point number 1. Point number 2 relates to partly paid up shares. Partly paid up shares may application sub point 1. Application will be made by the transferor to the company. Sub point 2. Company will not register the partly paid up shares unless company, or you can do it in a positive way. Application made by the transferor, Mr. A. Point number 2 क्या होगा? A gives application of transfer to company. Point number 2, company, and this is partly paid up shares or simple कर देते हैं इसको. Company will give a notice to, जल्दी बताओ किसको notice देगी company? Company will give notice to transferee Mr. B. In form number SH5. फिर क्या होगा? B will give no objection certificate to the company within how much time? Can I say 15 days? No, ma'am. Within 2 weeks from the date of receipt of this form. Oops. Have you written it? Because if I just try to pick up the cursor, it goes. Is that clear? So make your points and notes like these so that the things become very, very simple. Very good, Sunil, Pragya, Anubhav. 14 days, again, Anubhav, we will use the word within 2 weeks, whatever is written in the law. When they tell us days, we use days. When they tell months, we use months. When they tell weeks, we use weeks. Now, everyone is clear. SH4 is the form used for getting the transfer done. SH5 is specifically for the partly paid up shares. When you'll see these forms, again, you'll get more clarity. Now, transfer of the shares held by government nominees. In case of government securities, full exemption from the conditions laid down has been given. However, partial exemption in respect of transfer of bonds issued by government company. Now, if government company says that you have to transfer the securities, they have been exempted. They are fully exempted. They don't need to follow the provisions of section 56 subsection 1. Okay. Now let's understand the meaning of the word transmission. Transmission means devolution of title of securities otherwise than by transfer. For example, because of death, succession, inheritance, bankruptcy, marriage, etc. So these are the few cases in which the transmission or transmit ratios automatically by operation of. So if Mr. A has died, his legal heir will get the shares. If the person has been declared insolvent, okay, so your official assignee, whosoever is the person who has been appointed by the court, he will get your shares. If the person has become lunatic or mad, then the administrator will be appointed by the court. They will be handling your shares. Okay, so these are the cases for transmission of shares. On registering the transmission, the person entitled to transmission becomes the holder and he is entitled to all the rights and abilities. Now let's take a very interesting example. There was Mr. Ram who died. ध्यान से सुनना, बहुत interesting. And Ram's son was Sham. So he was holding 10,000 shares of Tata Motors. After death of Ram, will Sham get the 10,000 shares of Ram, his father? This is the case of transmission. Is that right? Yes, Mr. Kevin, I'm going to explain that point only that you have asked. Now, how will this transmission happen? How will you tell the company something needs to be sent to the company? In the previous case, the transferor, Mr. A, was going and filing the application with company. Will Ram go and tell company that, look, I have died. Please give my shares to Sham. His ghost will come. Who will go? No, ma'am, this is not possible. What are you talking? So here, there is no case of transferee. Here, though, the person who has died, Mr. Sham will only go and give the intimation of transmission. He will give a certificate of intimation that, look, my father has died. Now these shares get transmitted to you. So Sham will go and intimate the company that now I hold the shares on behalf of my father who has died. A notarized copy of death certificate has to be issued. Yes, a proof has to be given to the company that the person has actually died. So transfer is brought by delivery of proper instrument duty stamp, but transmission is done by forwarding the normal documents like death certificates to the company. Here, nobody is going to go and tell him that the person has died and now give it. Only the Sham will be a representative. Excellent, Anubhav. His representative, Mr. Sunil, Ms. P, all of you are. I think, Mr. Kevin, now your doubt is clear. So transmission is not going to happen automatically. Somebody has to go and inform the company. So it is known as intimation of transmission. So you can write down in your notes, intimation of transmission has to be given by operation of law where the rights get transmitted to another person. Instead of a transfer deed, it requires intimation of transmission, which means it has to be proved to the company. A proof has to be given to the company that the giving the reasons for transmission. Now let us go to the study material module. So children, whatever we are doing from my presentation, whatever we are understanding in the class, study material to padhna hai aap. Because in your CA, study material is the Bible. It has beautifully covered almost all the examples, explaining the entire concept. So please adopt a habit of reading your study material. Whenever you're sitting with me, making your notes, understanding, use highlighter, highlight your content in the study material, keep writing down short notes and points within your study material itself, so that on the exam day, you just have to refer one book, that is your study material. Although there are 3 modules, but yes, for a particular chapter, you only have to refer to that chapter. You don't have to look in for here and there for the different books. All right. Now, this is the procedure and formalities. फटाफट से करते हैं. Section 56 to 59. Transfer and transmission of securities. We have already discussed these points. For transfer, all this is clear to all of you. Now, example 12. Himanshu has received a notice from Chaitanya Progressive Books Private Limited on 7th August 2023, intimating that Shefali has submitted a transfer deed signed by her for transferring 500 partly paid up shares. Shares were for rupees 10 per share. How much has been paid up? Rupees 6 per share. Transfer हो रहा है. Who is the transferer? जल्दी जल्दी chat box में, because बहुत सारा syllabus पड़ा. Okay, Priyanka, we will do that example, but little later, please, because so much things are pending. Shefali is the transferer. Absolutely correct, because Himanshu has received the notice, na? So he is the transferee. So here, Himanshu as transferee will have to give the objection, no objection, that he has no objection, latest by 21st August 2023. So how have they calculated from 7th August to 21st August? What was the time period? Within how many days the no objection has to be given? Priyanka Pandey, Almas, Anubhav, Crispy, excellent, Rajvi Ray, within 2 weeks time period. Shailaja, absolutely correct. Clear example 12? Okay. In case of government companies, we have already discussed transfer of bonds. Only an intimation of the transferee will have to be given. No certificate is in existence or allotment. Then no proper duly stamp is required. So simple वो बोल रहे हैं. Full exemption है आपको अगर आपकी securities government company की transfer of shares की case. Power to register transmission not affected by section 56 of section 1. Now this is talking about the transmission. Transmission will not be affected by the conditions imposed for the registration. Company has the right to register the transmission if it has received the intimation. Simple बात कह रहा है जो मैंने अभी आपको बताई है. Intimation has to be given. In transmission, what do we use? Intimation of transmission. Intimation means inform करना, to inform by giving a death certificate or any other. So examiner can give you a 3 marks question related to what is the difference between transfer and transmission. There I expect you to write such kind of words. Okay, that transmission is devolution of title of securities, means you are no longer the owner because of death, succession, inheritance. And the person who is the legal heir will become the holder, and he will get all the liabilities and rights. And such kind of certificates has to be given as the intimation. So these are the better understanding. Death, I told you, insolvency, official receiver hota hai, lunatic. Lunatic means the person becomes mad. Now transfer of security to the deceased person, ये भी हमने बात कर ली है कि जिसकी डेथ हुई है वो नहीं जाएगा. The other person has to go and file the security. Richard Daniel, after having obtained the succession certificate, succeeded to 7,000 shares of ₹100 each allotted to her late father Alexander Daniel by Speed Software Limited. Now, read out this example very carefully. Richa was after obtaining. Richa is the person, the daughter, who has got the certificate from his father. Devolution, Anubhav, simple. You can look for the synonyms. Nothing difficult in that. Okay, basically, you no longer hold the rights of the share. So you can use any other word. There is no harm in that. So Richa has obtained the succession certificate. She got 7,000 shares of ₹100 allotted to her father Alexander by this company. To pay off the debt of her cousin Stesley, she wants to transfer whole of 7,000 shares to her on the basis of duly stamped instrument of transfer, which was signed by her as well as Stesley. Accordingly, she has delivered the required documents to the company for transferring of the shares. So Richa is a girl who has got the shares from her father. So that is the case of transfer or transmission. Jaldi batao. Richa को जो shares मिले हैं father से, that is the case of transmission. Richa जो shares दे रही है Stesley को, that is the case of. Very good, very good. First is transmission, then is transfer. The company, on receiving the transfer deed along with the share certificate and succession certificate भी चाहिए होगा ना, because shares have been transferred, will give the shares in favor of Stesley. Even though Richa is the representative, is not a holder of 7,000. The transfer effected is a valid transfer as it has been the holder of securities. Now, what is it trying to tell? Okay, although Richa is holding the shares of Alexander, is not a holder of 7,000 shares as per the register of members. Transfer was made by her in favor of the cousin is a valid as if she has been the holder of securities at the time of executing. Means that when I give the transmission certificate to the company is going to give me transferring the securities of the deceased, even if the LR is not a holder, then also he can execute a better transfer to another person. Say, for example, when in our example, Ram and Sham went to the company asking for Ram's shares who has died. Company took 1 month's time to do that. Company said, okay, it will take me 1 month's time because generally transfer and transmission, अभी आएगा नीचे time period, 1 month का time लग जाता है shares को transfer या transmit होने में. Meanwhile, children, can Sham transfer the shares to someone else? The answer is yes or no with respect to this example. Yes, the answer is yes. सबको समझ आ गया? A की डेथ हुई, शेयर्स B को मिलने थे, ट्रांसमिट होने थे. Before the transmission, can B sell the shares to C? Yes, ma'am, he can. Alternatively, Richa chose herself to get registered, in which case she made an application. Such an application will be accompanied. No need to submit the instrument of transfer because transmission में हमारी कोई transfer deed नहीं होती है because it cannot be signed by the deceased person. Is that clear, everyone? So this is just the summary of what we have discussed. Sure. Now here the time period is given. Now this is very, very simple. He's giving you what is the time period for delivery of certificates. Within how much time period the certificates have to be delivered. In case of the subscribers to the memorandum, the time period for delivery of the certificates is 2 months from the date of incorporation. In case of any allotment of securities, within 2 months from the date of allotment. So if you are a fresh memorandum subscriber, then within 2 months you should get the shares. Within how much time period the share certificates have to be allotted, transferred, or transmitted? It is giving you a time period. So if you're a new subscriber, then within 2 months. If allotment of securities, then again 2 months. But in case of transfer of securities, within 1 month. So this is not a very routine nature work. Transfer and transmission happens one-on-one basis. So whenever there is a case of transfer or transmission, generally 1 month's time period is taken by the company. And for debentures, it is 6 months time period. Okay. For debentures, it is 6 months time. A request for transfer of shares has been received by Pharma Labs Limited in SH4 along with the transfer of shares instrument. The company shall deliver the certificate by 24th December. So how much time period here the company has taken? In example number 14. No, Mr. Kevin, you only need to give the intimation in that case. So Pragya, you will not use the word 30 days, 1 month, all those who have written is the correct answer. And if you make any default, so this is the 3rd or 4th penalty that we're doing in this chapter, a penalty for any default of section 56. If you are transferring in a wrong way, you're not doing it correctly, then a penalty of rupees 50,000 will be charged. Is that clear to everyone? With the dematerialization process becoming a necessity of unlisted companies, we told you we have to simply follow these rules. Now, section 57 is very, very simple, children. Let's have a quick reading. If any person deceitfully personates, what is the meaning of personation? We have done it in the previous chapter. Yes, Priya Mishra, from whom are you asking for no objection? The person has already died, so no objection. आप किससे लेने जाओगे ना? Camouflage. Okay, Mr. Kevin. Excellent. Rajveer, fictitious name. Others, fake name. Priyanka, that's correct. Excellent, all of you. So any person is deceitfully personates as the owner of the security or the interest in a company. If actually the owner is Mr. A, but Mr. B goes and tells the company that I am the owner of the shares, or he tries to show a fake interest in the company, or he's using the share warrant or funds received for any other misusing the purpose, then simply usko ek penalty लगेगी and jail भी होगी. कितना जेल होता है उसको पेनल्टी लगेगी 3 years से लेकर 1 year की जेल हो सकती है एंड 1 lakh to 5 lakh rupees personation की पेनल्टी. It says personation of acquisition is offense under section 38, which you have already read, punishable under 447. Minded 447 is a general provision which tells you that what is the fraud, anything that you have done. All this refer to your chapter 3, which you have already covered with me in the previous chapter. Clear? Everyone, I hope no doubts here. Priya is asking for transferring the partly paid shares. I got confused. Yes, Kevin, we did the example of Ambani. Excellent. You remember that? That's great. Okay, somebody has asked about, Priya Mishra is asking when there are partly paid issues. So Priya, when there are, okay, this is another important point which I want to tell you about forced transfer. But first, let's clarify Priya's doubt. So partly paid up shares, 10 rupee ka share tha, 8 has been paid up, rupees 2 is pending. Harleen ma'am is the share certificate holder. Now I'm transferring these shares to Miss Priya Mishra. So now who will have to pay rupees 2 to the company, Harleen ma'am or Priya? Priya, because she is getting the shares. Very good. So company will be in a doubt. Company knows me because I am the member. Does company knows Priya? No, company does not know Priya. So company will go to Priya in SH5 form and ask, look, Priya, Harleen ma'am has transferred her shares to you, but they're partly paid up. Only rupees 8 are paid. Are you willing to pay me rupees 2 per share? Will you pay the pending amount? Priya will say, yes, yes, I have no objection. I fully trust Harleen ma'am. She's giving me the original share certificate. She has only paid up 8. I am the transferee. I give you an objection, no objection within 2 weeks, and then the transfer will set to be complete. Clear? समझ आ गया आप सबको? Everyone is clear about this? Good. A forced transfer is nullity and is not legal binding. Nullity means something which has no. Yes, yes, Miss P. In both the cases, that section 447 will apply. All right, good, Priya. I'm glad it's clear to you now. Okay. So forged transfer का मतलब होता है आपने forged signatures करे. Let's take a very simple and interesting example. There was Mr. A shareholder of Reliance. Mr. B forged his signatures. जैसे अभी पर्सनेशन करा वहां पे भी आपको पेनल्टी लगी, यहाँ पे आप forged signatures करो. Forged signatures means fake signatures. और ट्रांसफर करो शेयर्स किसी और. Is it a valid transfer? Law says if the true owner goes and tells, remember Sale of Goods Act? No one can get a better title if he has received the defective title from the seller. So if the seller is not the owner himself, how can the buyer get the original title? So if A is the real shareholder, Mr. B forged his signatures and transferred the shares to Mr. C. Mr. C sell it to further Mr. D. Now this Mr. A goes to the company and tells that, look, cheating has happened with me. Somebody has forged my signatures. मतलब झूठे signatures दस्तखत बनाए एक ही और transfer कर दिया. So law will restore the original ownership to Mr. A because forgery is nullity, means it has no value in the eyes of law. All these things are written over here. This transfer was void ab initio. It has no meaning in the eyes of law, which you can simply give it a reading. I'm glad, Priyanka Pandey, that you have written it's crystal clear now. So that's wonderful. So refusal of registration and appeal to transfer. Let's complete this topic also and then I will give you a brief. Okay, section 56 we have done, 57 we have done. We'll quickly try to understand section 58. Shares are a movable property, hence they can be transferred beyond. They have given you simple definitions about public and private company. Now notice of refusal. Now what is going to happen? Let's first see the table from my presentation. This we have done. So refusal to transfer. Now you are Mr. A and B who has transferred the shares. Yes, sir, it's the similar word that they're using here for the transferring. Okay. Mr. Kevin forged example basically means Mr. Kevin is a shareholder. Harleen ma'am, by cheating, picked up your shares. I signed Mr. Kevin fake signatures of yours and transferred the shares to Mr. Anubhav. So that is a forgery that I've done. Law says it has no value in the eyes of law. It has no meaning in the eyes of law. they will restore the original certificate back to Mr. Kevin. Okay. So refusal to transfer. Now you have understood the entire process of transferring the shares by one person to another. Now A want to transfer his shares to B. Let's take a date over here. Say for example on 1st April 2025, he wants to transfer his shares. Now here for the refusal of transfer का मतलब क्या होता है? Company ने मना कर दी. Company refused to register your transfer. And what will happen if company refuses? What will you do? Where will you go? If company refuses your transfer of shares, you will go to the court. And what is the name of the court in Companies Act? Tribunal. All right. Excellent. All those who have written, ma'am, we will go to the tribunal. So this is section 58. That company refuses to register your transfer. Then you have to go and file an appeal to the tribunal. Only the dates and time periods is the twist and turn that you have to learn and remember over here. So where a private company, so different cases, private company case में different time period है, public company case में different time. Where a private company refuses to register the shares, so A wants to transfer his shares to Mr. B on 1st April 2025. They made the transfer deed. He goes and files the transfer asking for the shares on 15th April 2025. On 15th April, he goes to the private company and tells that please give the shares to me. यही हमने पढ़ा था अभी transfer deed कि वो shares मांगेगा और shares उसको दे दिए जाएंगे. In the SH4 form, he is going to file. Company sends the notice of refusal. Company says, no, we are not going to register the transfer. So company has to give the notice of the refusal along with this reason. Within 30 days, the company will send the notice of refusal. So if I am Mr. B, I filed with the company on 15th April asking for the shares of the transferor. Notice of refusal should come back to me in 30 days from this date. 30 days means now B can go and file an appeal to the tribunal within next 30 days. So company has sent me the refusal within 30 days. Now I can go and file an appeal within next 30 days. I can file an appeal. Just listen what I'm trying to tell you. This much part is clear to everyone. That is, A went to B for transferring of the shares. A is trying to transfer the shares to B. B goes to the company for asking for the shares. Company refused to register the shares. Company should send the notice for the refusal within 30 days. And now Mr. B can further, in next 30 days, B can file an appeal with the tribunal. Clear yahan tak? In case no notice of rejection has been received. Now on 15th April, Mr. B went and asked for the shares. तो company ने ना तो shares दिए, ना तो transfer deed execute करी, ना ही कोई no refusal received within 60 days. Now B can file an appeal within 60 days of the execution. Okay, so company has to send the notice of refusal to transfer and transferee both the people. Or in case of the intimation that you have sent, then on the basis of intimation of transmission, it has to send the reasons. If a private company refuses to add B's name, then within 30 days, the company is going to send the refusal. Within further 30 days, B is going to file the notice with the appeal to the tribunal. And if no notice of refusal has been received, then B will file the appeal within 60 days of the transfer date. So within 60 days, 15th April को आप गए थे, वहां से 60 days में आप सीधा appeal file कर देना if you don't get the notice of refusal or neither you have got the shares. So with the notice has been received within 30 days, you go and file the appeal in next 30 days. If no notice has been received, then you file the appeal in how many days, children? "60 days is the correct answer. Very good. Dhanush, refusal of registration means company refuses to transfer your shares. You are Mr. A who said, please transfer the shares to A, transfer the shares to B and tells the company, please rename my name and add B's name. This is what is happening in transferring of the shares. But now company refuses. Whatever reason they have to tell the company, they have to tell Mr. B the reasons within 30 days, and the next 30 days, they will go and file the appeal against this notice. Yes, Pragya, you will have to wait for the 30 days and then only you will have to go and file an appeal. But where no notice of refusal has been received, then within 60 days you go and file the appeal with the tribunal. Now the only time period in this case is public company's time period is public company can't refuse without any sufficient cause. Now children, public company's shares are freely transferable. It is a valid contract whenever you transfer your shares to anybody else. So here, if public company is transferring without any sufficient reasons, then within 30 days, you can file an appeal. Within 30 days, they have to give again, this time period is same. 30 days, the notice of rejection should have come. The members can file an appeal within 60 days. If no notice of refusal has been received, then within 90 days. Let me show you the detailed discussion word to word over here so that you can get a clear understanding. So if a private company refuses to register the shares by operation of law or any other reasons, notice of refusal stating the reasons within 30 days from the date on which the instrument or intimation was delivered. So कितने time period में notice of refusal जाना चाहिए? 30 days. यहाँ पे लिख लो अपने subsection 1 के आगे 30 days. Clear हो गया? The shares and securities are freely transferable and it is a valid contract. We all know that. Now appeal to the tribunal. 30 days. Within 30 days of the receipt of the notice, you will file an appeal. 60 days where the date on which the instrument of transfer or intimation was delivered in case no notice has been sent by the company. So if company does not send you any notice, then within 60 days. Is that clear? 30 days, 60 days, 30 days, 30 days, 60 days is the case of private company. 30 days, 30 days, 60 days is the case of private company. And what is the case of public company? Jaldi se batao. 30 days, 60 days, 90 days. 30 days, notice of refusal. Next 30 days, 60 days, file an appeal. No notice has been received for refusal, 90 days. Look at here. Where the public company without any sufficient cause fails to register, 30 days they will send the notice. Appeal will be filed within 60 days of such refusal. If no intimation has been received, then within 90 days. Application received by public company for transferring of the shares on 25th November 2022. Transferee did not get any response from the company. By what date he can file the appeal? How many days they have done? 60 or 90 days? Very good, Almas. Miss P, excellent. 90 days is the correct answer. For example, 16. Example 15 भी पढ़ लेते हैं. Application received by private company for transferring the shares on 25th November 2022. Transferee did not get any response. प्राइवेट कंपनी के केस में कितनी देर तक आप अपील फाइल कर सकते हो? अगर आपको रिस्पॉन्स नहीं आया तो 30 डेज या 60 डेज? Excellent, 60 days. Okay, clear to everyone? You want me to take up the order of tribunal also, and then I give you the time to digest the information. Now I have made an appeal to the tribunal, and tribunal will pass an order. Transfer or transmission shall be registered by the company, and the company will comply this order within period of 10 days. Whatever the order tribunal is going to set up, if the tribunal may either dismiss the appeal or it will pass the order. Dismiss the appeal means cancel कर दिया, हमें ये appeal नहीं, या फिर order pass करा. So if tribunal directs the company that they have to register this deed, then within 10 days of the order, the company will have to comply with all the provisions of transfer and transmission. Or it will direct the rectification of registers and direct the company to pay the damages to the aggrieved party. What is the meaning of rectification of register? Tribunal will go to the company and tell that, look, Mr. A has transferred his shares to Mr. B. Quickly change the name of A to B. Why you have not done it? Why are you sending the notice of refusal? So once tribunal is satisfied that it is a valid transfer, he will rectify the register, get Mr. A's name removed, and Mr. B's name will added, and also to the aggrieved party who has filed the appeal, damages will be paid to them. Damages will be either of transfer and transferee, both of them. कोई भी appeal file कर सकता है और किसी को भी notice of refusal जा सकता है. And now if company tries to violate the orders of tribunal, my dear company, you are not obeying the tribunal. Court का order नहीं माना आपने, 1 to 3 years के लिए जेल में चले जाओ, and 1 to 5 lakhs penalty. So congratulations, it is the same penalty that we did in section 57. So penalties in both the cases is same, 1 to 3 years, 1 lakh to 5 lakh. So 57 and 58 की penalty by heart learn कर लेना, because those sections में same penalties are. So this is, now you will understand this summary that I was trying to take. Notice of refusal of transfer of shares by private company shall be sent only to the transferee within 30 days. No, notice has to be sent to both the transferor and transfer. All right, clear? So I know it's little technical and too much information I've shared with you. Section 56, 57, 58. I'm going to give you a 5 to 8 minutes break over here. Please learn it and I will ask you questions and then we will move ahead. All right. Okay, so we are going to take a break here. Students, I hope you have read the topic and understood the transfer and transmission. Kevin is asking, ma'am, can you explain the order of tribunal once again? So if A, okay, let's have a quick recap of section 56 is I think clear. Let's have a quick recap of section 50. A is transferring the shares to B. Transfer deed is going to be made. SH4 will be filed with the company. Company sends the notice of refusal in 30 days to both transferor and transfer. Now, within how many days, if it is a private company, within how many days I can file an appeal to the tribunal? Quickly answer me. 30 days. If no refusal was received, then 60 days. Dhanush has played safe, ma'am. 30 days if notice received, no notice, 60 days. Both the answers together. Okay, good. So now, Mr. Kevin, what will happen is, Miss Kirti, good. Now what is going to happen is that appeal has been filed to the tribunal. So tribunal is the court which will pass its judgment. It will pass the order that, look, company, that is not correct. It is a valid transfer. So you have to make the transfer. Now say tribunal passes this order on 10th of April. So within how many days the company will have to comply with this order? By 20th April, company needs to comply with this order because it says that direct the company to register the transfer within 10 days of the receipt of the order. So if tribunal's order has come on 10th of April, by what date the company needs to comply with this order? Means within what, how much time period? Tell me, children, in the chat box. By 20th of April, company needs to do this transfer. Correct? All of you understood? And also it will make ask them to make the rectification in their registers, means make the changes in the register and pay compensation to the person who has what is the meaning of compensation and damages? Again, Indian Contract Act, where you have suffered any problem, you had to file an appeal, your transfer has been delayed. All these reasons you can go and ask for the damages. And if you do any contravention, then there will be a fine and penalty. All my students are going to answer me, what is the fine and penalty for section 57 and section 58 default? What will be the penalty for section 57 and 58? One to 3 years imprisonment and 1 lakh to 5 lakh is your penalty amount. So I'm glad everyone has learned it. Harshada, good. Miss P, interest in the company, Miss P, like you are the owner of the shares or you have taken certain kind of interest. So it is the same thing that they're trying to use, that your interest in the company has been faked by some person. Whatever percentage of share that you're holding the company. Vemery, good. Kirti, excellent. Pragya, Varsha, Nidhi, Anubhav, all of you have given the correct answers. Good. Okay. So Miss Soumya, you can simply take it as a share only. So whatever the share certificates, warrants, coupons are basically received in case of rights issues. So whenever the right has been given to you, so similar kind of shares only you can take. Any personation of done any shares, that will be liable under section 57. Now let's move to rectification of register. We just heard this word that he will be asking for the rectification of registers. What is this rectification of registers of members? Section 59. Now this 59 is again interrelated with section 58, where you have filed an appeal with tribunal and tribunal has requested to do the rectification of the registers. So appeal can be filed for the rectification of registers of member if for any reason the name of the person is entered in the register. Without any cause, you have not entered the name of the person, you have omitted to enter his name. unnecessary delay is being made, then the aggrieved party will go to the tribunal or any other competent court outside India for the rights of these shareholders or debenture holders residing outside India. So if you are a person who is residing outside India, that person can also file a case with the competent court, or the tribunal case can be filed that my name has not been entered or my name has been omitted to be entered or delay is being taking place for entering my name. Then appeal will be filed to the tribunal or any other competent court. Now, what is tribunal going to do, children? Tribunal, after hearing the parties, either dismiss the appeal or pass the order. या तो वो appeal को खत्म कर देगा या order pass करेगा. जब वो ऑर्डर पास करेगा, अभी हमने ऑर्डर पढ़ा था, वो ट्रांसफर एंड ट्रांसमिशन को ऑर्डर पास करता है कि विद इन 10 days you have to rectify the register or you rectify the records of depository or the register and direct the company to pay the damages. So same order that you have done under section 58 is passed under section 59 if your name is not entered in the register of members. You are Mr. A, you have taken up the shares in the company or subscribers to the memorandum. Share certificate was to be issued to you. And what happens when you get the share certificate, your name gets entered in the register of members. Now it took so much time, your name has not been entered. You filed an appeal to the tribunal. Within how many days of tribunal's order, this transmission, transfer, or this share certificate's registration in the name has to be done for you? Again, within 10 days. And will you claim any compensation? Yes, ma'am, compensation will be given for the damage. This section protects the rights of the holder of security to transfer such shares where any person is acquiring the shares is getting the voting rights unless the voting rights are suspended by the order of tribunal. So when you get the shares transferred, children, tell me one thing. When A was transferring his shares to Mr. B, was he only getting the shares or was he also getting the voting rights? Yes, ma'am, he was getting the voting rights also. Any person acquiring the shares will also get the voting rights. But if it has been suspended, tribunal ने order pass करा कि आपको voting rights नहीं मिलेंगे, then any person acquiring such securities will not get the voting rights. Where the transfer is in contravention to the law, tribunal may direct the company to set right the contribution and rectify the register. So section 59 is not encountering any kind of penalties. वो कहते हैं अगर आपने contravention करा, तो simply tribunal will direct the company or depository because demat shares हैं. So he will ask them to please correct the rectification and make your records correct. So section 59 is very, very simple. You don't have to spend too much time in it. Simply your name has not been entered, name incorrect has been entered. You will simply file a tribunal. Case will be filed to the tribunal. If shares are in dematerial, how can person transfer before the procedure is completed? Ms. Shraddha, shares in case of, I think you joined late the class. So we have already explained in case of dematerialization, you don't have to follow section 56. Okay, then your demat shares, only for the physical shares, we follow section 56, the entire procedure. But 59 is talking about if your names are not entered in the records of depository or in the register of members, you will request the tribunal to pass the orders for the rectification. Yes, Priyanka. So now comes your very, very interesting and important and very vast topic. That is section 61, related to power of limited companies to alter the share capital, rights issue, bonus issue in next class. We will doing buyback also in next class. We will try our maximum capacity to do rights issue and reduction of share capital in today's class. Okay. But after doing section 61, I want to do certain important questions also with you. So we will first do section 61. Then we will understand and do certain questions also related to examination. All right. So section 61, alteration of share capital. Children, what is the meaning of alteration of share capital? Dhanush, at the end, we will do, if we keep repeating, but section 59, such a simple section, we'll not be able to complete the syllabus. Okay, you just read it once, you have any doubt, you ask. Okay, somebody has written authorized share capital is limit. How can a company issue the shares? Oh my God. Priyanka Pandey is saying, how can the company alter the share capital? Beta, section 61 follow karke we can. Okay, so don't worry. So company cannot alter its share capital. Absolutely correct, Priyanka Pandey. That company cannot change its authorized share capital. But you remember in chapter 2, you were altering your memorandum of association. So the company cannot change memorandum also, but we had certain section 13, 11, all those respective sections where we understood how the alteration of memorandum can be done. So here again, authorized share capital is a very important figure which you cannot change. But if you are trying to change, your authorized share capital, you will have to make an alteration in the capital clause of memorandum of association. So company limited with the share capital can alter its capital clause, that is memorandum, in the following ways, provided power of alteration is number one given the article. So the power of alteration has to be given by the articles of the association should allow you. अगर आपके articles आपको allow नहीं कर रहे हैं, if they're not giving the permission to alter the articles, then you cannot alter the articles of association. And you have to make an alteration in the capital clause of memorandum of association. Company may increase its authorized share capital. Now, these are the 5 ways how the alteration can be made. Number one, if my share capital is 10 crores and company says, now what is the authorized share capital? Jaldi bata do mujhe फटाफट. Authorized share capital hoti kya hai? It is the maximum amount which is stated in the capital clause of memorandum of association that we can raise, that the company can raise. So if it is 10 crores and now company thinks we are expanding our business, we want to increase our share capital to 20 crores. Or company feels like decreasing it, whatever company feels, they can do it as it thinks expedient. So if company wants to change this figure, they will alter the memorandum of association, maximum amount for the lifetime. Very how much a company can issue shares. Excellent. So this maximum amount can only be changed as per section 61, not any other ways. Section 61 has to be applied if the share authorized share capital has to be altered. Consolidate and divide the whole or any part of the share capital into shares of larger amount. So if you have the shares, 100 shares, 1000 shares of rupees 100 each. So that comes out to be 10,000. Now I want to make the shares of rupees 200 each. So I will need to increase or decrease this 1000. I am consolidating my shares of 1000 of rupees 100 each. Then dash shares have to be consolidated at the rate of rupees 200. Jaldi batao kitna hai? 500. So then I will have consolidate them 500 shares of rupees 200 each. You learned this consolidation and split in earlier also with me. I discussed it with you. So here I am decreasing the number of shares and I'm increasing the nominal value. Tribunal's order will be required only where this consolidation and subdivision changes the voting rights of the shares. So let's take an example. I am a shareholder, Mr. A, and I hold 50% of the voting rights. I am a shareholder B, I'm holding 30%. I am a shareholder, Mr. C, I'm holding 20%. Now, madam, if from 1000 shares of rupees 100 each, if company is doing 500 shares of rupees 200 each, that means company has done a consolidation. This should not affect the voting rights of the shareholders, that is A, B, and C. They will still hold the 50% voting rights, 30%, 20%. This is the meaning of this line. If it is any change is affecting, then you have to take the approval from the नेशनल कंपनी लॉ ट्राइब्यूनल. अगर आप किसी शेयर होल्डर के राइट के साथ छेड़छाड़ कर रहे हो तो आपको ट्राइब्यूनल के ऑर्डर लेना. Then company can convert its fully paid shares into stock or vice versa into any denomination. I told you fully paid shares are known as stock. You can either convert your shares into stock or you can even convert the stock into shares. Parijat Saha, you can join the Zoom session directly from where you're sending me the admin query. There is a link given. You can directly join the Zoom class also, or you can send your queries over here also. Not to worry, okay? subdivide the whole or part of the shares into shares of smaller amount, proportion or amount of the shares unpaid shall be same in case of. So you can reduce your shares also. So there is 100 shares of rupees 10 each. Now I've made 200 shares at the rate rupees 5. So this is subdivision can be. So here you are consolidating the shares into larger amount. Here you are subdividing into smaller amount. Yes, Mr. Kevin, excellent. He has admitted that, ma'am, we have learned this in accounts also. So entire chapter of your share capital and debentures, you have listened, you have heard about security premiums, discount issue of shares, about reduction, about bonus shares, everything you try to cover, and the advance accounts also. But the theoretical and law part is covered under corporate. I'm glad you can relate it to your practical. That's very good. And the last point is cancel the shares which have not been taken up and reduce the capital. Very, very important point. देखो first 4 points are very simple. Increase कर दो, consolidate कर दो, convert कर दो stock को shares में या shares को stock पे and subdivide. Very simple. Nothing much to discuss. Fifth point you all have to pay attention. The unsubscribed share capital. Now, if I have authorized share capital of 1,000 shares, but public has just subscribed and taken up 800 shares, then my 200 shares of the authorized share capital is the unsubscribed shares, which have not yet been taken up by the public. Now, if the company wants to cancel or diminish this share capital, it can say that, okay, I'm happy with this 800 only. In my memorandum, I will cancel and I will reduce. I will cancel those shares which have not been taken up. So 200 shares have not been taken up by the public. We cancel the shares. So हमारी authorized share capital and subscribed same हो गई अब कि हम 800 share capital ही issue करें. Can the company do that? Yes, ma'am. Under section 61, company can do. Will this cancellation of shares amount to reduction of share capital? Not at all. Please write down in your notes. You will write down in bold. This cancellation of unsubscribed share capital is not a reduction of share capital under section 66. मैं आपको भी under section 66 में बताऊंगी कि reduction of share capital क्या होता है. I think we are doing alteration today, so we will try to cover its synonyms, which is related to section 66 only. 61 and 66 are little interrelated, although they are not related. But yes, you will have to do section 66 with me today to understand the meaning of this line. So this cancellation of unsubscribed share capital is not the reduction of share capital, because share capital reduction has entire procedure to be followed under section 66. So अगर आप fifth point में alteration of share capital में अपने unsubscribed shares को cancel कर देते हो, that will not means you have reduced your capital, but it is not reduction of share capital under section 66. This cancellation of shares, see it is written. This cancellation of shares shall not deem to be. This cancellation of shares shall not deem to be reduction of share capital. So what are the 5 ways of reducing the share capital? Quickly in the chat box. Increase, consolidate, convert, subdivide, cancel. These 5 words I want in the chat box, which makes me sure that you have learned what is the alteration of share capital. Let's take a quick look in the Yes, Ms. Priyanka Pandey, excellent. That is very correct. All the subjects are interlinked. That is the beauty of your CA intermediate syllabus. Okay. See such words, unnecessary delay. He says it has not been defined. It depends from case to case. So if you ask me, ma'am, in section 59 also, what is the unnecessary delay? Somebody was asking about section 59. Listen carefully. Section 59 tells you that if your name has not been entered or omitted or any unnecessary delay. So law says there is no definition of unnecessary delay. Generally, within 1 month, your name should be entered. If it is not entered, please go and file the appeal to the tribunal. Within 10 days, your orders of tribunal, your things will be rectified and damages will be. After hearing both the parties of appeal over the removal of name of applicant from the register without any reason, tribunal passed the order to reinstate the name with the damages to be paid to the holder. Company has to pay the damages. अगर tribunal ने बोला damages देने हैं, तो company will have to pay the damages to the aggrieved party. Rights of the holder to the shares is protected. Transfer of securities, this all we have done. You again for the transfer of securities, you have to comply with the directions of Security Control Regulations, CARA, SEBI, Companies Act, and any other for time. Now, children, this is what we have started in today's session again. That is, yes, very good. Convert, consolidate, increase, subdivide, cancel. Everybody has written it correctly. So we have done the first part of this huge topic of alteration, that is power to alter the limited company. Now, this and this section 63 is very, very simple. We will do it in a flip of eye. This is little complicated, require a lot of understanding, and this is also very complicated, which we'll be covering in 16th April ki class mein along with debentures. But this is again a very huge topic, which I'm going to take up in a while with all of you, that is reduction of share capital. So authorized share capital, you all know what is authorized share capital. Authorized by the memorandum and called up is the amount which has been called up. Increase, consolidate, convert, subdivide, and cancel. A share with face value of ₹100 on which 80 is paid can be split into 10 shares of ₹10 nominal value, each with ₹8 being paid. What has been done over here? Consolidation or subdivision? Splitting of the shares has been done onto a lower value of amount. Okay? Absolutely correct. But all these things can be done only by passing a resolution in general meeting. So here there is no provision of SR. So that means ordinary resolution can be passed. Okay? Tribunal will require the consolidation. I told you if there are any changes in the voting rights of the shareholders, then tribunal's approval has to be taken. Within 30 days, a notice will be given in SH7, who will record and make the necessary alteration. And does the cancellation of shares amount to reduction of share capital? See, mind it. Reduction of share capital is covered under section 66. बता रहा है आपको पहले ही hint दे रहा है कि reduction of share capital तो आपको पता ही नहीं क्या होता है, वो तो हम section 66 में पढ़ेंगे. Clear? Now I am going to give you certain questions so that you can do some test of the questions, and then we are going to take up reduction of share capital also. Okay. So I think you have not done any question related to transfer of registration, right? Okay. Sweat equity shares you've already done with me. Okay, I'll give you a little complicated one so that your concept. Preference shares also we did last time the question. Huh? I'll give you the question related to transfer or transmission. So now there are three different types of questions just to understand the framing of the question. Mr. Nilesh has transferred 1,000 equity shares of Perfect Vision Private Limited to his sister, Miss Mukta. The company did not register this trade. Just a second, children, just a second. Okay. So Mr. Nilesh has transferred 1,000 of his equity shares of Perfect Vision Private Limited to his sister, Miss Mukta. Company did not register the transfer of shares and did not send the notice of refusal. Ms. Mukta, within the prescribed period, discuss the provisions whether aggrieved party has any rights against the company. Or the question can be, company refuses to register the transfer of shares made by Mr. X to Mr. Y. Company does not even send any notice of refusal. Does the aggrieved party has any right to take the action? Now, I am going to give you 2 minutes to think over this question. You can do an open book examination also. You can refer to respective section. I would want you to write in the chat box, what is the name of the section? Answers to both the points are same. So I want you to write the name of the section and what will be the provision if the notice would have been sent. Think, clarity with, take 2 minutes and write the answers in the chat. Those who have written section 58, that's amazing. So you were able to relate it with the correct section. Miss Kirubha, good. Dhanush, excellent. Soumya, Mr. Almas, Priyanka, Harshita, Kirti, good try, Kirti. You should mention the number of days also. Jandra, good. Somebody is talking 90 days. First of all, here it is a case which is related to section 58. Transfer has been refused. Whenever section 58 is being discussed, you always have to remember whether it is the case of private company or it is the case of public company. Here they have taken the example of private company. So in private company, within 30 days, the notice of refusal shall come. Even in public company, refusal shall come in 30 days. So this is common. But in private company, you need to file within 30 days if notice has been received or within 60 days if no notice has been received. So here it will be 60 days. If it would have been public company, like for X and Y, they have not mentioned the type of company. So you will mention both the points here, 60 days or 90 days, in case we assume it is a public company. Also, the order of tribunal will be final. So here is how you have to write this answer. The problem given in the question relate to section 58. In the present case, company has done a wrongful act by not sending the registration of transfer. Private company, if it refuses to transfer the shares, will send the notice of refusal to the company or to the transferee within the period of 30 days on receiving the transfer instrument or the intimation of transfer. Okay, whatever you have received within 30. Transferee may appeal within a period of 30 days from the date of notice, no notice within 60 days. So the company has not sent a notice, therefore Ms. Gupta will file an appeal within a period of 60 days from. So all those who are writing 90 days, it's not a correct answer. 60 days is the correct answer. But for the second case, X and Y, I told you, if it is not clarified, then you can give a hint that if it would have been a public company, then this would have been the answer. Okay, you enjoyed doing this question? You want to do more? All right, this is your preference here, so you can skip. Okay. Now this one is another interesting. Miss Pia, Mr. Kevin, all of you are correct children. Okay, Varsha Soumya says, ma'am, we want to do more questions. Okay. Yes, Mr. Kevin, absolutely correct. Ramesh, a resident of New Delhi, sent a transfer deed duly signed by him as transferee and his brother Suresh for registering the transfer deeds of Ryan Entertainment Private Limited. He did not receive the transfer share certificate even after the expiry of 4 months. Now, what is happening over here? He has not received the transfer deed after expiry of 4 months. He filed a criminal complaint in the court. Decide whether the court is competent to act in the said matter. Now, children, what is the time period within which the transfer and transmission should have happened? Anubhav Malik, absolutely correct. You can write down the point of the answer that you've said. Miss P, correct. Kiruba, incorrect. Oh my God, Kevin is saying 60 days. Almas is correct. Again, Harshvada, I told you not to use number of days where time period is given. Jandra is correct. Nidhi is correct. Shelja is correct. Priyanka, wrong. So 1 month is the time period that we have just done. So unless it is prohibited, any court order or tribunal will deliver the certificate within a period of 1 month from the date of receipt of the transfer order. If any default is made, then a penalty of 50,000 will be charged. Hence, the jurisdiction which is binding is the state on which the office is situated. Therefore, competent court of Delhi is not the competent authority. You can always file the case with the jurisdiction of the state where your office is situated. So if the company's office is in Bombay, why are you filing the case in Delhi? You will have to file the case with the Bombay office. Okay, so 2 points is made 1 month and the Bombay will be the competent court. Okay. Read the question very carefully and I want the answer in the chat box now. So again, the same points, consolidation, subdivision, increase, convert, cancel is the correct answer. And I'm so happy most of the students have replied the full answers, which means section 67 is now crystal clear and you have learned it in the class itself. All right. Section 62 we have not done yet. So now we will come back to the questions later on, but it was so much fun having these questions. And Priyanshi has also written, ma'am, cancellation will not lead to reduction of your capital. So that's great. And who is this child? Name. Mummy Dishiti. Mammy Dishti. Good answers, child. Good, good, good. All of you have given the correct answers. Wonderfully performed. So shall we move to reduction of share capital, children? because we have done alteration. So this right issue is ESOPs. If time permits, we'll start with the right issue, but let's right now do reduction of share capital. So reduction is very, very vast. I don't want to leave a single point. So I'm taking the entire topic from the study material itself. Okay. Because if I try to explain you briefly, then many of the points will be left. So I don't want to leave any single point. Buyback and reduction दो ऐसे topic है जो थोड़े से lengthy हैं, but they are so much fun to understand. And children, like I try to motivate you. I try to tell you before starting the topic that this topic is very interesting. It is fun to learn it. Similarly, whenever you open your law books, always open the law books with a happy and smiling face. When you are happy about studying a subject, never think that, oh my God, too much syllabus I have to do. How will I manage? How will I learn? When I use such kind of expressions, so much anxiety and stress I have already sent to myself. And when I have told myself that it is so huge and it is so stressful, it becomes very difficult for your brain to understand that whether it is easy or not. So you have to make your subject easy by motivating yourself. Keep giving yourself a patting. Like for all these questions that you've answered, come on, give yourself a good patting. Wonderful answers you have given. Trust me, when I was a student, I could not retain the information so fast the way you are retaining it. So that's great. All right. So always motivate yourself and try to make yourself understand that, yes, whenever I'm going to open the book, I am going to enjoy learning and reading about it. Okay. Very good, Priyanshi. Priyanshi says, ma'am, this happens with me. Thank you so much, Miss Soumya. I'm glad you feel motivated by these kind of things. So that is the purpose. All right. Miss Nidhi, what you have not understood in alteration, you want me to revise alteration? So alteration is just simply increasing your share capital or converting it into stock, consolidating, subdividing, or cancelling the shares which have not been taken up by the company. Okay. Thank you, Priyansha Pandey. I know, children, you do feel demotivated at times, but always remember, simple as the rule, whenever opening the book, keep a smile on your face. Okay? All right, Nidhi, clear your point. Kevin is also writing something. Let me read what is he saying. Yes, definitely, Kevin. We'll try to make the reduction of share capital also very crisp and simple for you. So now this is my challenge that all my students have to find it simple. So let's accept this challenge and move forward for the reduction of share capital. Reduction of share capital, what is the layman's language it is trying to do? Ma'am, half an hour back you told us altering the share capital. That was means making changes in the share capital, increasing, consolidating, subdividing. But you told us one thing that if I'm cancelling the shares, it is not reduction. So then what is reduction? Reduction of share capital means if my share capital, the paid up share capital in my books is 100 crores, and now I want to reduce it to 80 crores, that means I am going to reduce my share capital. Here the word reduction is starting to come into picture. Now children, whenever your share capital, देखो शेयर कैपिटल, आपकी जो कैपिटल है जिसके साथ आप बिजनेस कर रहे हैं, अगर आप उसके साथ छेड़खानी करते हो, मींस इफ यू आर ट्राइंग टू मेक इट कम डाउन, then there are two important people who will be affected by it. One is your creditors and debt holders, and other is your shareholders. Okay, so we are going to understand how these people are going to be impacted adversely, or steps have to be taken by the company so that they are not affected. So conservation of capital is the main principle of company law, because reduction diminishes the fund. Whatever money with which I'm doing the business, now I'm going to cut down short to it. Either because excessive capital has come up with me and my business is not doing really well, I don't need this much capital, I want to reduce it. Or reducing the liability of shares which are not paid up. So my shares were for rupees 10 each. Rupees 8 were paid up. I called up rupees 8 and rupees 8 were paid up. How much liability was pending? Rupees 2 were pending to be paid up. The company changed my mind. I have reduced my share price to rupees 80. Wow, the shareholders are happy. Our liability has been reduced. We have already paid rupees 8. Now we don't need to pay balance rupees 2. So that is the first method of diminishing the liability of shareholders. Extinguishing or reducing the liabilities. Now I'm going to tell you the methods. What are the methods for reduction of the share capital? So reduction can be done by passing SR. यहाँ पे हमने बड़ा बड़ा लिख लेना SR. Alteration of share capital में क्या था? OR था SR था? बताओ. Alteration of share capital had OR. There was no mention about SR. It was just written resolution. So we assume. Reduction of share capital में क्या है? SR. To be confirmed by tribunal. Were you going to tribunal for alteration? Did we go to tribunal to ask, Judge Sahab, we are altering a share capital. Do you have any objection? No, ma'am, you never mentioned that we were going to tribunal. We to simply learned increase, consolidate, subdivide, and that cancellation. Simple 5 points we have learned for the alteration. We did not go to tribunal. We did not pass it. But reduction of share capital, just look at them. SR is required. Gather the shareholders, ask them, invite them, and tribunal's confirmation is required. Can anyone tell me randomly why I'm going to ask the court when I'm reducing my share capital? Is it that important, ma'am, that we would need to ask the tribunal? Why do you think? Because, ma'am, my creditors are standing there in the books. I have to pay money to them. Look, you are reducing your share capital. Please take court's permission. Are the creditors happy with this? The stakeholders, the shareholders, I hope their interest is not being affected. Excellent, all of you. Kevin, Priyanka, Miss P, very good. Rajbir, because we are affecting the third parties are involved. So that's why we have to take the confirmation from tribunal. So first 2 points done. SR is required, confirmation from tribunal. Now here you will write down the heading. What is reduction of share capital? Meaning here, there are 3 ways of reducing the share capital. Extinguish or reduce the liability on the shares which have not been paid up. For example, में आप क्या लिखेंगे? The share was for ₹10. Ma'am just told us ₹8 was paid up. Now the company has decided to reduce the liability and we want it to be a share of ₹8 only. So shareholder will not need to pay the balance to ₹2. Therefore, company has reduced the price per share. Shareholder will not have to pay any more further liability. Shareholder की liability reduce हो जाएगी. इसको बोलते हैं extinguish कर देना या reduce कर. First point is clear. Everyone. Cancel any paid up share capital which is lost or is not represented by the available assets. Now, in the balance sheet, children, what does it shows us? One is your liability side. Another is your asset side. Now, my liabilities are showing 1,000 crores of share capital. But my assets are showing 850 crores. How much balance has disappeared? 150 or 250 crores? 150 crores? All my math students. Is that right? So now, company will say, I have lost my assets or my 1,000 is not equivalent to 850. So I will need to cancel my paid up share capital for 150 CRs and now it becomes 850 CR vis-a-vis 850 CR. So when my paid up share capital is lost or is not having equal assets, company is cancelling or writing off the 150 crores so that no benefit is given to the shareholders, neither any losses happen. Here the company is writing off the assets which are not being represented with the corresponding capital. All right. So this example you have written, all of you. Third is pay off any paid up share capital, which is in excess of the wants of the company. Now, company has received a share capital, company was really doing well, and company has received a share capital of 1,000 crores. But as per the needs and requirements of the company, it is happy to do the business with 800 crores. हमें नहीं चाहिए excessive capital, 200 crore की excess आ गई है. So please pay off the excessive capital. If the paid up share capital is excess, then the company will repay. Company feels it can do well with 800 crores only, then it will reduce its share capital to 800 crores. Provided company has not made any defaulting in repaying the depositors. So depositors are the people who have deposited their money with the company or the creditors. There should be no default in that. Then only you can reduce. Otherwise, the defaulters, the depositors will say, you have not paid my money and look, you are reducing your share capital. Look, company, first pay my paisa वापस. Then only you reduce your share capital. So law says, please don't do any cheating with the depositors. So you should not have made any default. You will get this point written in the head in the notes, okay? So let's quickly have a recap of what we have done till now. Reduction of the capital will happen by passing SRC. They are again going to show you this line SR. So first, let's understand what are the three ways of reducing. Extinguish kar dena ya reduce kar dena means you have reduced your share capital. Yes, that is why Priyanka Pandey, yes, company can do reduction as per section 66. Only as per section 66 you can. Soumya is asking what is this extinguish? Extinguish means right, khatam kar. Finish. 10 rupees were to be paid. Now only 8 rupees to be paid. Rupees 2 is extinguished. Finish. Over. No, Miss P, that is not related to fraud. It is only saying that your paid up share capital is, your certain capital is lost or it is not. So you're not having sufficient assets in equivalent to that. That is also another way of reducing your share capital. Definitely, Anubhav. They return the amount back to the shareholders, paying back. So here you extinguish or reduce, you cancel the paid up share capital balance sheet wala example, yahan pe rupees 10 to 8 wala example. If the company has received excessive amount of paid up share capital, please return it back. We don't want if my requirements are less. But only point I told you over here is the depositor's default should not have been made. Now please pass this. And now we are going to understand the procedure. So keep making down these notes. We understood what is reduction of share capital. Now we are understanding the procedure. Pass the SR, alter the MOA. In alteration also we were altering the MOA, right? Here also we are going to alter the MOA. And repayment of deposits either before or after or interest payable cannot be in area. अभी मैंने क्या बताया? Default नहीं होना चाहिए. Deposits की जो payments है, whatever deposits you have received from outsiders as per the SAT, they should have been repaid. There should not be any fraud in respect of these deposits. Clear? 3 points clear. SR, MOA, tribunals approval also. And deposit default nahi honi chahiye. 4th point yahan likh lena, tribunals approval. Okay, sorry, here it is. In respect of share of rupees 10, sorry, a company has called up 7 per share and the same has been paid. Company decides not to call the remaining rupees 3 and reduces its shareholders' liability. If this is done, that means company has reduced its share from 10 to rupees 7 fully paid up. Therefore, reduction of share. We have reduced from 10 to 8. Here it is giving. So, Nidhi, it is the same meaning. Diminishing means khatam kar dena, finish. All these are synonyms for reduction. Extinguishes, diminishes, reduces, pays off, writes off. Everything we are trying to reduce the share capital. Okay, children? Now we will issue of notice by the tribunal. I told you, you have to take the tribunal's order. So tribunal will give the notice after making the application to CG. So tribunal will go to CG. Now tribunal is going to take the approval from 4 parties. आसान नहीं है रिडक्शन ऑफ शेयर कैपिटल करना, बहुत बड़ा काम है भाई. आप शेयर कैपिटल अपनी रिड्यूस करे, ऑथराइज्ड शेयर कैपिटल में चेंजेस कर रहे थे, एमओए में ऑल्टर कर रहे थे, वो ऑल्टरेशन थी सेक्शन 61 में. यहाँ तो आप पेड अप शेयर कैपिटल जो पेड अप है उसके अगेंस्ट के एसेट्स नहीं है, राइट ऑफ कर रहे हो, रीजन देना पड़ेगा, ट्राइब्यूनल से अप्रूवल लेना पड़ेगा. एंड ट्राइब्यूनल इज गोइंग टू मेक द एप्लीकेशन टू सीजी, सेंट्रल गवर्नमेंट. नाउ इट इज रीजनल डायरेक्टर, रजिस्ट्रार, SEBI and the creditors of the company. Tribunal will go and ask the creditors, are you okay with this? He will either take their consent, or he will either see the creditors have been paid off, or any security has been given to the creditors. Creditors should not be dissatisfied with the reduction. Then you cannot reduce the share capital. Tribunal will consider the representations from them, and within a period of 3 months. So within a period of 3 months, tribunal will have to take the confirmation from these 4 points. If no representation has been received, we will thought that it is no objection. अगर हमें कोई 3 months में नहीं आता है कुछ confirmation, then we will think that there is no objection. Please go ahead with this reduction. Considering representation is statutorily required, not admitting it in full. So you have to do this. Let's see example number 24. See how beautifully study material has covered everything. There they have put up an example for you so that you don't have to do a brainstorm. एक बार रिवाइज कर लेते हैं. अभी हमने क्या पढ़ा है? How to do the reduction, procedure for reduction, tribunal's order, 3 months time period and 4 parties. Now example 20. Application for reduction of share capital received by NCLT on 22nd November from unlisted company. So reduction of share capital was received by tribunal on 22nd November. He sent a notice to the RD, ROC and creditors on 28th November. So within time period he has sent. Now this notice was sent in the registered post which reached them on 1st December. So what is the time period by which they should have made the representation? Within 3 months from 1st December, or you're going to count from 28th November? Tell me. From the date of receipt of notice, it is given. Excellent. So you have received it on 1st December. So within 3 months, you have to count. So December, Jan and February. So it will be 3 months. So this is the beauty of 3 months, children. If you count 90 days, it is not 90 days. Because February में कम है दिन. So तभी मैं बोलती हूँ months लिखा है तो months करो, days लिखा है तो days करो. वही याद करो. 3 headings are clear. 4th heading. Now what order tribunal is going to pass? Tribunal will say, okay, go reduce your share capital. But on such terms and conditions that I am going to tell you. Your claim from the creditors should be discharged, pay off kar do, determine karo kitna hai, secured karo, and consent of creditors. So 3 important points have to be followed. Creditors' consent has to be taken, or just discharge them and pay off them, or they have been secured. The creditor's claim should be clarified, then only you can reduce. Also, he will ask for the auditor's report. Have you done the accounting treatment as per the accounting standards? I hope company you are not doing any fraud. Somebody is writing in the chat box, ma'am, company fraud तो नहीं कर रही. भाई कैसे कर देगी? Tribunal पूरा डंडा लेके खड़ा है उसके सिर. Is going to check your accounting statements also. Reduction of share capital में children, you are not doing any fraud if you are doing it as per section 68. Simply you have to follow the rules. Okay, clear? Nidhi is asking, ma'am, what is the meaning of special resolution? Nidhi, I think you have come to my class for the first time. Children, fatapat se tell me what is the meaning of special resolution. At least 75% of the shareholders should have agreed for any resolution. Okay. So Nidhi, refer to my previous lectures also. Your doubts will get clear. Good. All those who have answered more than 75% votes in favor. So we will do this resolution topic in the chapter MGT whenever we discuss that chapter, management and administration. Okay. As of now, you can simply remember. Accounting treatment has to be seen. So how tribunal determines whether the accounting treatment has been received? Simply take the auditor's reports. Don't do so much of brainstorming. While making an application, a certificate to the effect of the company's auditors has to be filed. क्या ट्राइब्यूनल थोड़ी ना जाके कंपनी का देखेगा, चलो जी अकाउंट्स निकालो, मुझे देखना है कि आपने करा है कि नहीं. Okay. So tribunal is not going to come and see whether accounting standards have been followed. He will simply ask for the auditor's copy. So let's precise it now. What we have to consider for passing the order, the tribunal will have to consider the creditor's claim has been satisfied or the consent has been taken, and also he will check the accounting standards have been followed as per the auditor's report. Order of tribunal will be final. You will have to fulfill the order. Within 30 days of receiving the order of tribunal, a copy has to be filed with the registrar. We have not been going to the registrar. Anubhav, it's the same that they have to be discharged, means just pay off them. Determined means you have to find how much amount to be paid. Tribunal should be clear that how much amount you're going to pay. Okay. So within 30 days, you have to file the copy of the tribunal to the registrar and giving all these details, amount of share capital, number of shares into which it is divided, what is the amount of each share now, date of registration to be paid off. All these points will be clear. Nothing in this section will apply to buyback of securities. We are not going to touch this line. Simple samajh lo, section 66 is not section 60. Section 61, cancellation was not section 66. Remember, section 66 is not section 60. अलग है ना, section ही अलग है, buyback नहीं हुआ. So section 66 is not applicable to section 68. What is section 68, ma'am? Next please. No liability of members. A member, whether in past or present, shall be liable to pay the amount, maximum amount, the difference which has been paid. So whatever amount has to be paid, that has to be paid. Your voting rights, creditors' rights will not be affected. Where the creditor is entitled to object, but was not included in the list of creditors. Now, this is very, very amazing. Subsection 8, ध्यान से सुनिए. Company had a creditor to whom they have to pay rupees 100, but they have said that only rupees 2 were to be paid. You're trying to defraud. Here you're trying to do cheating. If you're reducing the share capital and the creditor has objected, but you have not included his list in the name because his ignorance of the proceedings or nature of interest, company commits a default under insolvency and bankruptcy. अगर कंपनी ने ऐसी गलती करी, if company has done such a mistake that you have not included the name of the creditor in the list, then it will be considered as a mistake under insolvency and bankruptcy. Action to claim the creditor's good, remedy will be available. What such situation is available if the company is running its operations? Then every person who was a member on the date of the registration of order of reduction will be liable to make the compensation, not exceeding the amount which was liable to contribute if the company has commenced the winding. अब क्या compensation pay करनी है हमने इस creditor को? All the members who are part of the company will be liable to pay amount not exceeding to the amount which would have been to be paid. If 100 rupees were to be paid, entire amount would have been paid to. If the winding up has started, and if the really winding up has started, then you make a list of persons who are liable to contribute and orders have to be passed for the winding up of the company. Let's make it a little more clear from the example. Name and interest of Mr. Nilanjan Iyer, a creditor of Modern Furniture Limited, was kept outside the list of the companies. While the company did the reduction, now you have made the list, you are taking the help of tribunal. Tribunal is going to the creditors, SEBI, all these big bodies, to the registrar, the central government, and this name of this creditor was not there, Mr. Nilanjan Iyer. Later, when Iyer came to know, he took a legal action against the insolvency and bankruptcy, as the limitation period has not yet expired. So he was entitled to do so. Exclusion of his name will be offense under IBC. IBC is insolvency bankruptcy. हमारे Companies Act में नहीं उसका आ रहा. वो कह रहा है आपने insolvency and bankruptcy code के according you have done a mistake. Yes, Kevin, company has deliberately not added or because of any ignorance, it will be considered as a default. Is that clear? No penalty, Anubhav. They are only saying that the company will be liable to under insolvency and bankruptcy. Period of limitation, if you remember, Limitation Act has set up the period of limitation, which is time barred. So you can simply leave it. It is just trying to tell you that this is not your Limitation Act clearance. It is the insolvency and bankruptcy code will be followed in this case. Rights of contributories, you can leave this point. Liability of the officers. If you conceal the name, now here you are doing it knowingly. 447 is going to come into picture. Abates means you encourage, you are trying to do commit a crime. You are knowingly representing the nature of debt. Now here I gave you an example of the same point. You are concealing the name of the creditor. There are creditors A, B and C. But you जानबूझकर, abates means जानबूझकर आपने encourage करा, abate करना, conceal करना. You are hiding his name. If you are trying to do this intentionally, or his liability was 100 and you have shown rupees 2, misrepresentation करा, तो 447 will be applicable against that. So in the case of creditors, they are trying to tell you 2 points. One is that please, when you go to the tribunal will ask creditors, are you discharged? Your rate is determined. Your consent is taken. Are you secured? And auditor's approval will be taken, seeing that the accounting treatment has been followed. यहाँ तक clear? अब अगर तो creditors के नाम, if the name has been skipped out, as per insolvency and bankruptcy code, action can be taken. One is that one. Second is where you are intentionally trying to create a fraud. Now, I am a company, ABC Limited, and I want to reduce my share capital just because my creditors are very huge and I try to do some cheating. There are 100 crore creditors standing and I just showed 2 crore when filing an application to the tribunal. So I'm trying to cheat. 447. आप करके देखो ऐसा हेरफेर. 447 is always behind you. Never ever try to commit any kind of mistakes when you're running a company. So section 66 tries to cover you very beautifully. First, you have to learn what is reduction of share capital test. ले लूं आपका साथ साथ फटाफट से. नहीं मैम, अभी तो पढ़ा है इतनी जल्दी. हाँ, yeah, good Priyanka. So Kevin says मैम ले लूं. Okay, फटाफट से केस में डिफरेंस क्या हुआ फिर? Anubhav, in that case, you are following insolvency and bankruptcy code. Here you are talking specifically of intentional mistake. Okay. So what are the 3 cases? Define reduction of share capital. 3 points. Jaldi, jaldi. Extinguish or diminish, paying off the liabilities, writing off the assets in support to that. Cancelling, paying off, reducing. Very good. So मैं reduction में reducing ही लिख दिया. Extinguish use करते word, diminish use करते word, right? जैसे alteration में हमने 5 words learn करे, यहाँ पे हमने क्या learn करना है? Extinguish the share capital. You have to learn the words extinguish or reduce. Cancel the paid up share capital which is lost. Pay off the excessive capital. Good Almaz, Kevin, Vimri, Shailaja. Miss P, good. What is the procedure for reduction of share capital? 3 points, 4 points. I want you to answer 4 points. What is the procedure for reduction of share capital? Number 1, SR. Number 2, SR ही लिखते जा रहे हैं. Number 2, no default in the deposits and interest. Alter the memorandum of association. And tribunal's approval. Rajbir, here we will not directly say consent from creditors. We are trying to learn it in the sequence given in the book. So we will say approval of tribunal. Now coming to the third set, tribunal will make application to 4 parties. कौन सी है वो? Creditors, ROC, CG, SEBI in case of listed companies. CG's power has been delegated to whom? Very good, RD, regional director. And once the reply, then what will happen? What is going to happen then? Tribunal will ask these 4 parties, are you okay with the reduction? And within how much time period approval shall come? 3 months. Very good. If no reply has come, then company will feel that everything is okay. Okay. And also the tribunal will go to 2 parties then. He will make sure that the creditor's consent is taken, no default, security has been paid, and they are being discharged. Okay. And auditor's approval report has to be taken that the accounts have been followed in as per accounting standards under section 133. And then you have to go to the registrar within how many days? Within 30 days. What all has to be filed with the registrar? Tribunal is going to send a summary of all the details. What are those 4 details? Can anyone tell me? Tribunal will file the copy of the order of tribunal will be filed by the company with the registrar within 30 days. What all? You can do cheating from the book. It's okay. You can cheat it and answer me, children. Very good, Kevin. Amount of share capital. Second, yes, Soumya. Number of shares, amount of each share, and amount at the time of registration deemed to be paid off. Rihanna, excellent. Vemery, excellent, all of you. Sunil Kumar. Oh my God, my children have learned reduction of share capital today itself. Amazing. So now next question is reduction of share capital and buyback same? Section 67 is applicable to section 68 also? Very good. Everyone, no ma'am, no ma'am. Good. And then if the creditor's name is not entered by any reason of his own ignorance and the reduction has been done, this default is under Companies Act or under IBC, Insolvency Bankruptcy Code. If the creditor's name is not entered in the list of creditors because of his own ignorance of the proceedings, then it will be, oh my God, excellent, it will be IBC case. But if any officer knowingly conceals the name of the creditor or misrepresents the nature or amount of debt, then he will be liable to dash, dash, dash. What? Then he will be liable to section 447. Clear, children? So now I'm going to look for certain questions. If you have any doubts, you can ask. Yes, Anubhav, ignorant hai. I told you, ignorant of proceedings means that is not intentional. All right. So quickly write in the chat box, what are the sections that we have covered today? All of you will write. I have a question for all of you. We can do that. Yes, Miss P, excellent. We have done section 56, 57, 58, 59, 61, and section 66. Very good, Pravya. So I was trying to take up certain more questions with you. Still have 5 minutes. Okay. Let's take up one question. One MCQ. Thank you, Mr. Kevin. I'm so glad that all the sections are clear to you, and I hope you enjoyed the session, all of you. And the best part is that you are making an effort to learn the things in the class itself. So well done. Give yourself a patting, all of you. Thank you, Miss Memory. I'm so glad to know this. Excellent. So B is the correct answer. I don't know why D has been given by so many of you. So 2 weeks time period was to be seen. So company shall not register the partly paid up shares transfer unless the company has sent a notice in SH5. And please remind me in the next class of this SH4 and SH5. I've already downloaded the forms for you. So we'll try to see the forms. Within 2 weeks, you have to file SH5. Is that clear? So well done, students. Most of you have written answer correct. Now, day after tomorrow's class is more important. Every class is important, although. So section 62, we are going to finish up. Further issue of share capital. We'll be doing buyback. We will be understanding a little bit section for bonus and 64, 65. And sorry, 63 and 64. And then we will move to debentures after we are done with the buyback of securities. All right. Thank you so much. And it was wonderful teaching all of you. And I can read so many beautiful messages of thank you, Mr. Anubhav, Ms. P, Pragya, Priyanka, all of you, Ms. Soumya. Thank you, children. So please revise whatever we have done in the class and see you all on 16th. Thank you, Priyanshi. Thank you, Priyanka Pandey, Vemri, Nidhi, all of you. Nidhi, I hope things are clear to you. But do refer to the previous lectures if you have missed out anything. Thank you, Mr. Kevin. All right. I cannot see any doubts. Let me just see in the chat box. Only thank you messages are there. Thank you, Mr. M.A. Okay. Yes, Shelja, all the notes will be there. Don't worry. Definitely you'll get for shape uploads. Okay. Yes, Nidhi, you want to say something? All right. Thank you, Ms. Priyanka. I'm so glad to read this. I think, sir, we are done. There are no queries, only the thank you messages are there. Yes, sir. Thank you so much.